Good morning, everyone. I was going to be doing the Jones Works amended complaint, but I got sidetracked last night. Um, I've got a 6-year-old child. It was Frozen. Now it's K-pop Demon Hunters, and I have to endure for the. We're now past the millionth time. The K-pop Demon Hunters film, which is an incredibly good film, actually. I do recommend it. Um, but you will get bored if your child becomes obsessed with it. And if I have to listen to Golden again, which is an absolutely incredible song, great showcasing of vocal range, but um, it's bad enough that I hear it with almost every TikTok video. I now have to listen to it on repeat, either on Alexa or on YouTube through my daughter. And yeah, if anyone's ever been through that stage with their child and knows how to just make it stop, um, please do give me some advice and hit me up in the comments. That'd be so appreciated. But we also had an order from Judge Lyman. There was a hearing yesterday. I saw the TMZ footage of the interview with Brian Friedman afterwards, where he had this huge smile across his face and resembled the Cheshire Cat from Alice in Wonderland. And I was here for that. That was amazing. Obviously, something went really well. He mentioned an order that would be coming out later on, and it did. But again, like I say, I was at the mercy of my little one. So I have the order here. I'm just going to go through that really quickly. And then I will do a separate video for the Jones Works amended complaint. Okay, so the court held a post-discovery status conference in the related matters. So that's the Lively action and the Jones action, which, remember, they are actually separate cases, but they are consolidated and have overlapping themes. As indicated, right, today, December 9th, as indicated on the record at the conference. Now that discovery is largely completed, parties in both cases are directed to contact chambers of Magistrate Judge K for the purpose of exploring possible settlement. The court expresses no view with respect to settlement. Now, I know a lot of people, I've already seen a few comments. A lot of people will be thinking, oh, that he's forcing them to do this. He is. He's forcing them to sit and consider and attempt settlement. He's not forcing them to settle. He's forcing them to sit down and kind of attempt to try and agree a settlement to avoid a trial. And that happens in every single civil litigation case. It does in the UK as well. This is a completely normal part of the process. And if he didn't do it, there would be a lot of eyebrows raised. So, to give you an example, in the UK, for instance, every single non-criminal matter is dealt with by, you've got to consider in good faith mediation or settlement. And what that means is whether it be a debt or like a family proceedings which involve like child arrangements, where you're basically trying to decide how much time does the child spend with each parent, how many holidays does a particular parent get to take them, are they allowed to take them out the country, what if the mum divorces dad, wants to revert back to her maiden name, does she get to change the child's name? If she gets remarried, can she give the child her new married name? How much maintenance is the absent parent going to pay? All that kind of stuff. And even in divorce, you cannot get divorced You can't go through divorce proceedings unless you've been through something serious, which um, for which there is an exemption, such as domestic violence. You have to attempt mediation before going to the court. So these kind of things are perfectly normal part of, you know, these court proceedings in civil cases. And the judge saying, "Can you please go and sit and think about whether you are able to come up with a settlement agreement between yourselves in an attempt to avoid a trial," is a completely normal part of this course. He's not telling them they have to agree on a settlement. They just need to attempt it in good faith. If they can't agree, that's when there's, someone will sign off to say, "No, we tried and it didn't work, so this needs to go court," and then the court will proceed. The judge has to already be working on the basis that it's going to court. That's why a trial date was set. I know that's moved, and we'll get to that in a minute, but that's why trial dates were set, and, you are doing some pre-litigation stuff as if, the trial is gonna go ahead because you have to be prepared for it. But, obviously, if you can and many people do actually, go and sit down, talk things through, with mediators or arbitrators, and they are able to avoid a lengthy, expensive trial because they do find middle ground and something they can agree to. And that if that happens, that's the end of the case at that point. The judge will sign off on that. Over in the UK, it's called a consent order, where the parties, basically they draft up like a joint stipulation, and the judge stamps it to say, "Yep, okay," and then the stamp gives it all the power of a court order, where, if one party fails to adhere to it, they can be found in contempt of court and face the penalties for that. Um, so that's what that is. Perfectly normal. I'm not surprised. I'm not flappy about it. It's a good thing. They were actually invited to do it before at the very start. Both parties declined at that point, but you know, there comes a point where they have to try, and as the judge says, now discovery is over. So this is the right time to be putting this forward. And we continue. Parties in both cases are directed to meet and confer regarding their anticipated motions for continued sealing, and to the extent possible to file a joint sealing letter on December 19th regarding documents and matters over which the parties agree sealing is appropriate. In line with prior practice, where the court orders any audio or visual materials unsealed, the parties who submitted the materials to the court are directed to provide CD copies to the clerk's office, along with a copy of the court's unsealing order within 2 business days. So, what's happening there? The Livelies, predominantly Lively, I'm going to say it. A lot of the stuff that the exhibits that are attached to various motions are sealed. Wayfarer have, for the most part, unsealed their exhibits, including their exhibits that have been included by either Lively or Jones in their oppositions, where the Wayfarer parties would have had to agree to just have them unsealed, and they have done that. I did the video yesterday. No, sorry, I did the video the other day of deposition transcripts. Alex Sachs, Jamie Heath, Justin Baldoni, they were actually attached to Lively's opposition for motion for summary judgment. So even though they weren't her exhibits, but they were her exhibits in the sense that she attached them, but they were deposition transcripts of other people. Those people had already said, "Okay, just unseal it. I don't need it sealed." So I was able to read it. Everything else was sealed. Everything from anyone else was sealed. I haven't seen anything from Lively herself, text messages or deposition transcript, nothing from her husband, and a lot of other cast members like Isabella Ferrer, Colleen Hoover. There's Leslie Sloan. Her deposition transcript was sealed. There was a bunch of stuff filed as exhibits that are still unsealed, that are still sealed, and the judge is sitting there going, "Oh, look, I'm not going to sit and go through all of these and decide, whether they need unsealing or not. You figure it out amongst you because there are still too many on the docket that are sealed, and there is a right of public access to these, to these exhibits." Um, I will repeat because I stand by it. Almost all of them are Lively's, and she can't avoid it forever, is what the judge has basically told her. So they have now got to figure that out, put together a letter by next week, telling the judge jointly, you know, this needs to stay sealed for, and they've got to give good reasons, and the judge will decide on them. And then they've got to say, well, these ones can all be unsealed. And then we'll get a flurry of exhibits that are unsealed. And I will be going like the clappers, trying to get it all put together to go through it all, so you guys can all see and hear what is in these exhibits, what interesting nuggets of information there is. And more importantly, what has Lively been trying to prevent us all seeing? Okay. Oral argument regarding Wayfarer Party's motion for judgment on the pleadings and motion for summary judgment, and Lively's motion for spoliation sanctions is scheduled for January 22nd, 9:30, and that will be in the New York courthouse. Now, that one was a bit interesting. That one caught me off guard a little bit. I could not find any precedent for that happening before. I'm not saying it hasn't happened. I couldn't find it. Maybe someone else will. I think I don't know. I mean, there's a lot on the docket. There are, so many sanctions motions. You got these big motions for judgment on the pleadings and summary judgment. There's a lot of reading to do. There was a lot of exhibits to look at. And again, I think this is partly why the trial date is obviously moved, which we'll come to next. But I do think there are some issues here that they may set a precedent. Lively is, although it probably won't be part of this hearing, Lively is still pursuing Section 47.1, the treble damages, etc., the sexual harassment privilege. That would be a case of first impression. It's never been decided upon in any court. Now, judge clearly in the motion to dismiss order, where he dismissed Wayfarer's claims, he really did not want to touch that. But he almost reluctantly invited Lively to say, look, if you really want this, make an argument, because he's got to. If anyone is going to appeal anything and everything, it was going to be Lively. And if he hadn't, she would have appealed it. So he had to. She did. She filed her motion for that. So it's still sitting there. And he's got also she's trying to claim that FIHA should apply outside of California. Wayfarer obviously pushing back and going no. Some of these are precedent setting decisions, and I think there's a lot of complexity around them. The judge has really got to have, he's got to read everything, but he's also got to hear the various arguments. I do think the judge is trying to keep his house in order as well, and keep a really tight record for potential appeals. I can see Lively appealing. I think Wayfarer are going to appeal their some of their stuff. But I think, and I've said this from the start, right? I do think the reason a lot of people are like, oh, he's got biased towards library. I'm not saying he's not. There are decisions where I think, oh, did you really need to give her that? Definitely. But there are a lot of decisions where it's frustrating. It feels unfair. But also I can see that he's probably in the long run, it may do Wayfarer a favour. Because if you can avoid giving Lively grounds to appeal, then that makes a big problem go away, right? So, I mean, even right down to um, Wayfarer noticed Lively subpoena. Therefore, they should have been the ones to decide where that was going to take place. There was a whole motion because Lively did not want to go 2 miles further to their offices, their law firm. So, and the judge gave it to her, and it's such a petty thing, right? But it's also like I'm sitting there thinking, well, I can see it's just not worth the argument. It's not worth the risk of Lively appealing, saying that she was disadvantaged in some way, you know. And I think, Wayfarer. I think Wayfarer know this as well, because the last thing you want is all this time and effort and money to be put into this trial for Wayfarer to say go to the trial, defeat Lively's claims, come out victorious, and then for her to say, well, I'm going to appeal because I was disadvantaged because during my deposition, I, you know, it was held at Fritz's law firm and not Manat, and that put me at a disadvantage because I felt unsafe. And when a woman who is claiming sexual harassment is citing concerns for her safety, it's hard for a judge to sit there and say, well, you're still not getting your way. And if Lively does not get her own way, she is going to appeal because we are in this court case full stop because Lively did not get her way, or, she was told no occasionally and didn't like it. That's the whole foundation for this lawsuit. So it is an absolute given in my mind that, it's better to just give her some wins at this stage to reduce her chances of having anything to try to appeal. That's just my view. Again, do I think all of the decisions are fair? Absolutely not. Absolutely not. I think Wayfarer also know that as well because they now cite Lyman's cases specifically, like, one or two dotted in with other cases when you're, putting in a filing and you're citing cases as well to back up your arguments. One or two of that specific judge is quite common. Where they are citing 5 or 6 or nearly the entire where possible, nearly the entire case citation is of that judge. It tells me that they feel a bit uneasy, and feel that the judge is being unfair. Okay. So, yeah, that's just some thoughts on that. So there's it's quite a lot going on with the oral hearing, I think, but I do think the judge is making sure that his record keeping is tight. I think because he's anticipating potential appeals if this does not go in Lively's direction. I actually see it as a good thing. In many ways, I think it might benefit Wayfarer. So, okay. And if I was Wayfarer, I'd be sending in Shapiro to argue in this oral hearing on these motions. But that's my view. I don't know who they'll send in on the day. I do think Alexandra Shapiro should be the one to do it, though, because she is the appeal expert. So she can do the argument at a high level and almost in preparation for we may have to appeal this, like because everyone's got to do their groundwork for appeal, not just the judge. Okay, oral argument. No, I've done that one, haven't I? Trial in the lively action is adjourned to May 18th at 9 a.m. The final pretrial conference is adjourned to April 21st at 10:30, both to occur in the courthouse in New York. The joint pretrial order, motions in limine, and proposed voir dire and jury instructions are due on March 20th, with oppositions and responses due March 27th. Okay. There's quite a simple reason why this has been moved. I said it was going to be moved months ago. The case is just too big. It's big. It's a big case, and there are also related and consolidated actions as well. There is a lot of stuff to get through. The judge has got so much on his desk. He's got all these various motions for sanctions, summary judgment, judgment on the pleadings. He's still dealing with motions to compel, even though discovery has closed. There will be an absolute bunch of stuff that he has to go through, and it would have been impossible. It would have been really impossible to get to the March date that was set. The judge has also got, and I've said this so many times, I'm sure people think that this is the one and only case in front of him, but it's not. He's got hundreds and hundreds of cases, and in US federal courts, he's got both criminal and civil, and criminal has to take priority over civil, which is rightly so. Some people, they may be kind of incarcerated while awaiting a trial, or they may be waiting for appeals, and you've got deadlines for these things, which are tied up in the Constitution, so you can't just move them. These are people's, civil rights. So the criminal cases have to take priority, and he's still working all of those cases. So, we're seeing all of these filings and decisions that he's got to make just in this case alone, and it's terrifying. He has that with all his other cases. And I imagine that his job is incredibly hard. We've seen him do a couple of late night orders, a couple of weekend orders as well. So he is constantly, he's working very long hours. And there was no way he was ever going to get all of this case all together and ready to go on March the 9th. There was also the government shutdown as well. So federal courts are part of the government, so that they all have this knock-on effect and has caused a backlog. I think this is a good thing. I think it gives everyone more time to prepare. Obviously the trial date moves. Everything else before it, all the pre-trial stuff, also has to move. Because it kind of, has to all go together. So that's that. And then at the end, then he says, in the Jones action, the parties shall meet and confer and file a proposed schedule for the Jones parties' motion to amend their complaint and motions for summary judgment. The parties should also discuss and propose a schedule for Jones Works' motion for bifurcation in the lively action, which ideally will be fully submitted shortly after oral argument in the lively action on January 22nd. So, bifurcation, what that actually means is it's the process of dividing a case into two or more separate stages for trial. And it allows for specific issues to be resolved independently, where you determine liability in one stage and then damages in another. Essentially, it allows the court to address an aspect of a case without having to resolve all of the issues at once, and then that helps streamline the process. So where that might apply is, like Jen Abel has both her complaint, her general complaint against Jones Works, but then she's also got a separate indemnity claim against Jones Works. Jen Abel's also in the Lively. She's a defendant in the Lively action, and then she has filed a motion for conditional summary judgment against Jones Works, because obviously Wayfarer filed for summary judgment against Lively, all of the Wayfarer defendants, including Jen Abel. But then she has filed a separate motion for conditional summary judgment against Jones Works, which essentially is, if Jen Abel does not win, does not defeat Lively's claims, and is found liable for retaliation against Lively, she is saying to the judge, she's asking him basically, can you make a decision and grant me conditional summary judgment where if Jen Abel is found liable in the Lively action, which is going to be heard before the Jones Works one, if the conditional summary judgment is granted, then that puts Jones Works on the hook for Jen Abel's damages, as she was, Jones Works employee, so it would be like a vicarious liability. However, but then Jones Works would not then stump up Lively's fees, or they might. It could be held in abeyance, which is where it's just kind of like, like just sitting. And then the Jones Works trial against Jen Abel would then begin, and Jen Abel would have to win her case against Jones Works also for Jones Works to be, kind of responsible for Lively's damages in the event Lively wins. So that's how that kind of all works. Yeah. So effectively, the conditional summary judgment a judge would grant that or deny it. That's stage one. So if it's granted, we move on to stage two, which would be Abel has to defeat Lively's claim. She has to win against Blake Lively in the Lively action. And she has to lose. I'm getting myself confused now. Jen Abel has to go, the Lively trial will go ahead. Jen Abel loses the Lively trial, is found liable for damages. But there is this conditional summary judgment sitting here pending, it's been granted. So that puts it on to Stephanie Jones and Jones Works to be liable now for these damages that have been awarded to Lively against Jen Abel. But that's not the end of it. Then Jen Abel has to then go head to head in her trial against Jones Works and win. She has to win. She has to defeat Stephanie Jones's claims against her, but she also has to win her complaints for Jones Works to actually part with any money to pay Blake Lively in the event that Blake Lively wins. And that's how that works. I hope that kind of makes it a bit clear. Maybe I'll do some kind of flow chart to show how it's done at some point. But that's kind of the crux of how these things work. So, and that's an example when he says bifurcation, that's what he's like, these things need to be passed out. There are separate issues, and we need to figure out how to deal with one issue at this point and, deal with the other issue at a later point. So yeah, that's it all basically as explained as best possible. I hope it makes some sense. If anyone has any questions, please do put them in the comments. I always reply to comments and questions. But I hope that kind of explains how this all works. But I think that the first big thing we're going to have is going to be the letter about the unsealing, which is due on December 19th. So we will see what they all agree can be unsealed and what they say can't be unsealed, and we will find out more on December the 19th. All right, I'll leave it there for now, and I will be back later with the Jones Works amended complaint. All right, guys, I'll speak to you later.